So the situation here in Utah is bad, and more people need to understand how bad it is. And this is the workers' compensation system in Utah, and I'll briefly explain how it's supposed to work and then how it's actually working here in Utah. So how it's supposed to work is if you get injured on the job, you don't have to prove any negligence or anything. You just have to prove, in order to get workers' compensation insurance, is that you were injured on the job. And I guess the idea is you're giving up having to prove negligence. It's making it easier for you to get insurance. And what you're giving up is all the damages that you get in a typical torts case, like pain and suffering, punitive damages, stuff like that. You don't get those same kind of damages. You get way less damages. And the damages you get depends on your average weekly wage. If you make X amount, you get essentially 60% of your average weekly wage, but it's actually capped too. So if you make a lot of money, if you make more than the cap, you'll get paid a lot less. And so you get paid for the time off you're off work, but then also if something happens, like if you lose an arm or a leg or something, or if it can't work as much as it could moving forward, you get a percentage of your average weekly wage. And so there's a weekly amount attached to every member of your body. So if you lose your arm, you'll get like 120 weeks or something of your average weekly wage to compensate you for your lost arm, which really doesn't compensate you for it. But how it works here in Utah, how it's actually working, is if you're a younger person and you get injured, usually there's no problem. You're a young person, you'll recover quickly, and they're typically okay paying out younger people. If you're an older person, like in your 50s or 60s, and you get injured on the job, they will usually fight that tooth and nail and say that, oh, it was a pre-existing condition. And so if the insurance denies it, then you have to go through the Labor Commission, which is kind of like the appeal, to get your insurance. And that is where all the problems begin. There's only like 3 or 4 administrative law judges for the entire state of Utah for all the employees. So what does that mean? Very high caseloads. They're overworked. It takes a lot of time for them to get decisions. It takes forever for you to get a hearing, and it does take forever to get a hearing. Sometimes I'd request a hearing and I wouldn't get a hearing a year out. And then if the other side wants to continue the hearing, you won't get another hearing for another 6 months plus. That's a big issue. The other issue is if the judge finds that there's a controversy in the case. So if they find that that their expert says something different compared to what your doctor said, they'll send it to a medical panel. And I'll just say from my experience, the other side always just sends it to doctors, and they'll get the doctors to say whatever they want. And and a lot of times they don't make any logical sense from an attorney perspective, but they still are to say that, oh, hey, there's a controversy. And so if there's a controversy, you have the hearing, but then the judge listens to the facts, but then the judge says, oh, well, there's a controversy, so we need to send it to the medical panel. So they send it to a medical panel, and again, that could take a year plus for you to even get that hearing, and the medical panel can take even longer, because these are just doctors out of the goodness of their hearts coming and looking at these cases, and the medical panel can take years. It can take 1, 2, 3 plus. You're at the mercy of the medical review panel and coming up with a decision. And if you don't like the medical review panel and want to appeal it, that process in itself can take 1, 2 years, just for how long it takes for the single administrative law judge to get back to the case. So it is a big, big problem in Utah. And the problem is, because of how long it takes, it allows the workers' insurance companies, it incentivizes them just to deny cases and put it through this process and string people through this crazy process, and they know how long it is, and they use that as threats to say, okay, well, if you don't take our bad settlement offer, then we're going to string this thing out for years and years and years. And nobody should ever be able to use how bad the system is as leverage, but they are. And I've written to my state representatives. They don't care. They are not doing anything. One time my state representative said, oh, hey, well, we're not in session, so I'm not doing anything for you, which I was not happy about. But I think more people in Utah need to be aware about how bad the system is, which I think will help at least get forward to getting some kind of change here in Utah. I mean, my thing is, I don't think that administrative law judges should be the ones handling this workload. We have millions of people here in Utah. Tons of people have jobs. There's not enough judges for this, and so it either needs to be sent to commissioners, where there's commissioners in every county, or it needs to be sent to actual judges to review these cases. But there's a big problem, and it raises, in my mind, a lot of constitutional issues, like under the state constitution, you have right open courts clause, and the right to access courts. And so if this is how the system's working and it's taking years, and sometimes they take even longer than a typical personal injury case, which shouldn't be the case. This should be a lot faster, but they're taking longer. And so that could be a violation of someone's open court clause rights. Also, the other thing is, if you have, like in a typical, it's just funny because in a typical personal injury case, I mean, pre-existing condition is somewhat of an argument, but it really isn't the fight of the argument. And they really don't focus on it as much. But in these workers' comp cases, they focus on it 100%. And it's just funny on how, like, in a typical personal injury case, it's not that big a deal. They know it's an uphill battle to claim pre-existing condition, but here it's at the full front because that's the only argument they can make, and they're just grasping onto it. So really, like, the argument that, oh, hey, like, these cases will be easier, you just have to prove you're injured on the job, it's proving it's not the case. And tons of these companies spend tons and tons of money on these on their own medical examiners to come up with these decisions. And sometimes they'll spend so much money, and they'll get 3 or 4 to come out with opinions, and then you have to combat 4 different opinions. Nobody has the money to do that. And the problem is, too, because of how long it takes, and the process, and how much little money there is involved, not a lot of attorneys in Utah do workers' compensation cases. And it was so bad where there was a decision that said that you couldn't get any attorney fees in workers' comp cases based off an interpretation of a case that later has been reversed, which is helpful. So now you can recover attorney fees, which has made it somewhat more helpful for attorneys to say, okay, this might be worth it. But still, the system is bad. It's really, really bad. It needs to be changed. Spread the word. Best way is public awareness about the system. Hopefully we can get traction, and this worker comp system can get to the point where cases are actually addressed in a timely manner.